Former President Trump's fourth arraignment could look a bit different. There's a possibility it could be on camera. Georgia allows cameras in its courtroom as long as they do not disrupt proceedings. Trump and his allies have until August 25th to turn themselves in. The 98-page indictment in Fulton County, Georgia, alleges a criminal enterprise involving former President Donald Trump and 18 co-defendants. That includes some familiar names like Trump's former attorney, Rudy Giuliani, and former White House Chief of Staff, Mark Meadows. Other names you may be hearing for the first time: publicist Travian Kuti is accused of helping pressure a Georgia elections worker into falsely admitting to fraud, while Georgia Republican official Kathy Latham was accused in a separate lawsuit of breaching the state's voting system, although she denies involvement in that case. District Attorney Fani Willis says she would like a trial to begin within 6 months, and she wants to try all 19 co-defendants at the same time. Trump has repeatedly denied wrongdoing. I want to bring in criminal defense attorney Don Samuel. He's represented the Fulton County Board of Elections, the Georgia General Assembly and Senate in legal proceedings related to the 2020 election, and he's represented some notable celebrities such as Ray Lewis and the rapper T.I. Thank you for joining us. First, I want to get to whether or not this is a benefit for the prosecution to put all 19 co-defendants on trial at the same time.
Well, I'm skeptical, frankly, Jerika, that they're really going to have 19 defendants at the same time on trial. I think the goal of the prosecution is to see if some of the defendants will turn on each other, turn on others, and see if they can kind of whittle down the numbers just by virtue of having everybody in the same courtroom. That typically happens in RICO cases. They make very good offers to some of the defendants to see if they can, get them to testify against other defendants. It's unmanageable to really have 19 defendants on trial at the same time. And it's really not a benefit at trial for the DA to do that because of the chaos and the prosecution having to deal with 19 sets of criminal defense attorneys, all against, one assistant DA or a couple of ADAs trying to manage the entire case.
Right. And I can only imagine what that would be like for the jurors as they're trying to keep all that information straight and together. What does the district attorney, though, really need to show a jury in order to prove that this was a, quote, as she noted in the document, that 98-page indictment, a criminal enterprise?
The law in Georgia is pretty favorable to the prosecution in most RICO cases. It's even more lenient than the federal RICO statute. In Georgia, all they have to do is prove that the people are essentially an association in fact, or just a group of people with a common goal. There doesn't have to be any, specific way in which the organization is formed. There doesn't have to be a partnership agreement. Doesn't have to be a corporation. Doesn't even have to be the mafia. Just a group of people, all with a common goal, engaged in a pattern of illegal activity. So I think the indictment alleges that. It alleges it. I'm not saying that they can prove it, but it certainly says that everybody was linked together as a group, and even if they didn't even all know each other, they all had a common goal and were all willing to participate to achieve that goal through a pattern of a variety of different crimes.
Yeah,
that's
and they
the
outline,
allegation.
I was going to say, and they outlined several other states that they claim this type of enterprise was happening in. When you think about it from a defense attorney standpoint, what sort of strategies do you see the defense teams implementing in this case?
Well, I think that, the defendants are a disparate group, but what is really astounding when you look at the indictment is that there's 19 defendants, 9 of whom are lawyers. That's a very unusual indictment to have 9 lawyers. Well, almost half the defendants in this case are lawyers, including people who worked for the Department of Justice, including people who were, former prosecutors, a number of civil lawyers. This is not corrupt lawyers who were engaged in this. So it's an intriguing case that, in essence, the lawyers are being prosecuted for their advocacy. And there are lines that, lawyers shouldn't cross. There's no doubt about that. We can't suborn perjury. Lawyers can't, bribe witnesses. I'm not saying that lawyers can do or say anything, but gosh, I mean, to speak on behalf of a client and to advocate on behalf of a client, to trust that what your client is telling you is truthful and then advocate on that position. We're not judges. The lawyers are not judges. We're advocates for clients. So it's most unusual in that regard. But again, if there are lines that are very clearly drawn of what a lawyer can't do.
Right.
As I said, you can't witnesses, you can't suborn perjury, you can't encourage witnesses to lie. So that's the most intriguing part of this case, really, to me, other than the fact that the former president of the United States is one of the defendants.
And
other than that, it's an unusual case.
Yeah, absolutely. I mean, all of this is, we continue to use this word over and over again, but it truly is unprecedented. When you look at some of this indictment and what you've been able to look at, what do you think is the most damning evidence that the prosecution is putting forward?
Well, obviously, they have a lot of taped conversations, recorded conversations that are, they're almost the equivalent of wiretaps in a case involving organized crime. I mean, there's a lot of undeniable facts in here. It's not, it's not a whodunit. It's not the kind of case where the defendant's going to say, "I was in Anchorage, I didn't do this. Someone else did this," or there was some misunderstanding. There's a lot of undisputed facts that the defendant's state of mind is certainly, a critical issue. But the prosecution is not going to have a hard time proving that, defendant A said something on a certain occasion, to the state legislature or to, on a telephone call that was taped with the Secretary of State. Those are undeniable facts.
Right.
So that's a troubling part of the case for the defense. They can't challenge the government's prosecution's ability to prove that certain things, in fact, were said. That's not going to be, the defense that can be raised here.
And we've heard so much now with this indictment from the prosecution side. It'll be interesting to see, as more information comes out, what the defense will be to some of these alleged crimes. Don Samuel, we thank you for helping us understand what we can at this point, but of course, there'll be more to come. Thank you.
Thank you. Thank you for inviting me. I appreciate it.